Welcome to this recording of the Q&A section of Win This Together, which was our third episode of this mediation advocacy webinar series that we hosted with IDEX Legal. My name is Jonathan Rodrigues. I'm a mediator at CAMP, and joining me today is Ms. Shantha Chellappa, who's a senior mediator and also a director at CAMP. Thank you for joining us, Shantha ma'am.
Thank you, Jonathan.
All right, so we had a fantastic session last Thursday where we talked about the role of the lawyer in navigating deadlocks during a mediation. And it was an amazing session with different insights from the panelists. And we had a few very interesting questions. Now, some of these questions might be very relevant beyond the webinar because these are like frequently asked questions where lawyers and clients do pose these questions to us when they reach out to us at CAMP. And some of these things might be relevant to you beyond, as I said, the context of just navigating deadlocks during a mediation. So one of the most interesting questions that was posed was, I think this comes from the fact that we have this understanding that mediators cannot give suggestions or mediators cannot give opinions or cannot propose solutions. So if the mediator cannot do all that, then how can she or he have a way of exploring options for resolution during an impasse? So you have reached deadlock, you have reached a roadblock, and if you don't have the power to suggest or give opinions, how do you break this deadlock? And that's the question. Shantha ma'am, in your opinion, how do you think the mediator can do that?
This is a very important question, Jonathan, because this situation happens to every mediator in any one of the mediations. In such cases, the mediator can revisit the underlying needs and interests of the parties only in order for the parties to get clarity and to reconfirm to themselves what is important to them. We need to sort of suggest to them or need to make them understand that there are certain things which are very important to them. Encourage each party to acknowledge the interest of the other party, even if they do not agree with it. So you help them to identify any common interest between the parties while you are encouraging them to address the needs of the other party also. Also, the mediator can help the parties to have clarity on the target they can realistically achieve. Mm-hmm. Bottom line, within which they may not accept or which is likely to reject. The range within which they may accept by asking several open-ended questions. The mediator can also explore the options each party would like to consider, keeping in mind the interest of the other party to further understand both the parties' needs and interests. The mediator can also suggest hypothetically, what if this offer is made by the other party? Would it interest you? Mediator can also spotlight the progress made by listing the issues involved and the issues resolved to encourage the parties to move towards complete resolution. The mediator can try and enlist the help of an influencer who can help the parties to take a decision. Mm-hmm. Help the parties to brainstorm several options without any compulsion. There is no need for them to compulsorily look at any option, but right. Them might interest them. That's how we can try and break the impasse, since we are not in a position to suggest solution to them.
That's a very interesting take, Shantha ma'am. And I think this comes from the fact that we always say that you don't really have to give an idea yourself. I think the role of the mediator here is to kind of plant the idea in the minds of the counsels and the parties by asking them relevant questions and gathering enough information. And if you have heard Shantha ma'am's response clearly, it's about saying that the mediator has a toolkit to deal with an impasse. And it's the role of the lawyer here, the mediation advocate, to tap into this toolkit that the mediator has and use these different tools and techniques that the mediator has to actually break that impasse. So the mediation lawyer has to be aware of this, that an impasse does not mean the end of the road, but give the mediator a chance to explore the different tools that he or she has to break an impasse. Now, in particular, issues of breaking an impasse, sometimes mediators suggest a break, or they might just temporarily pause the mediation or go and address another point on the agenda. And this is fine if, both parties agree to that technique of taking a break, parking a certain issue. But what if both parties don't agree to that kind of, a response by the mediator? Both parties say something like, we need to address this now, before going ahead to any other issues, and they are very adamant about it. So what happens in those kind of situations, Shantha ma'am? How do you break? Is even suggesting a break something that's you would advise, or are there better options besides that?
In my experience, Jonathan, suggesting a break is a good method to ensure parties to go back and sleep on the issue, come back with a cool head. Most of the time it works. But sometimes, as you said, it may not work also. The parties' emotions are at a very high level. Maybe they just want to resolve the issue then and there. Then the mediator has to try and explore what are the underlying need or an interest of both the parties to insist on a particular issues to be taken first.
Right.
Pushing them to take a position about that issue. To explore the ways to address the said interest. And you can also, the mediator can also help the parties to explore whether there is any common interest in that issue to resolve so that the main issue can be resolved well. And also help them to find various ways to integrate their interests together. Another way a mediator can try is to revisit the agenda already set, or set an agenda, defining the issues to be resolved from most important to less important. Help the parties to see where the issue, which they are adamant about, stands, or whether this issue is the core of the dispute. That's very important. If it is the core of the dispute, unless the said issue is resolved, you may not able to move forward.
Right.
Whether the issue can be separated from other issues, which can be resolved amicably. Help them to understand that the value in resolving the other issues so that that gap is narrowed down to look at the issue of which they are very particular about in a different perspective. This might help the parties because once they calm down, understand the value of the issues to be decided first, then I feel that the parties will certainly come around to look at the issue in a different perspective.
That's very interesting, Shantha ma'am, because you talk about separating the person from the problem, separating one problem from multiple problems that seem to be all attached together. And, kind of decongesting that whole situation is something that the mediator can do. So once again, to all the mediation lawyers out there, the mediator has different skills and techniques in his or her toolkit. And it's your duty to tap into this toolkit, ask the mediator to help you and your client get past this impasse. Once again, an impasse is not the end of the road. As they say, it's just a bend in the road, and the mediator can find the way out of it, and you can work with the mediator to help your client get out of that impasse. Thank you so much for joining us today. Thank you, Shantha.
Yeah. One thing I would like to add is that, Jonathan, if the mediator and the advocate are on the same page, if they work together, they can really work wonders. Thanks for
Absolutely.
me for this, Jonathan.
Absolutely. Thank you so much.
Thank you.